Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today I'm going to talk about how to regulate your children either using social media or from being posted on social media in the context of divorce and family law cases. As of late, the impact social media can have on children has become more and more of an issue, and it's really been brought to the forefront of people's awareness that social media really can negatively impact children, whether it is their private, confidential information being posted by others, whether it's parents or other third parties, or whether it is their actual use of social media and being on there with friends, being exposed to a lot of the negativity that is out there on the internet. And a book I would encourage you to read, it's called The Anxious Generation by Jonathan Haidt. It's been on the New York bestseller list for quite some time, and it really sheds light on how social media and the smartphone age has had a negative impact on children and how parents may want to shield their children from these devices and social media platforms until they reach an older age. Ideally, you and your spouse would be on the same page as far as how you want your children to interact with social media and whether or not you want them posted on social media by third parties, whether it's the parents themselves or daycare providers, athletic teams, etc. So hopefully you can reach an agreement and put in language that says, children will not have Instagram accounts or TikTok accounts until a certain age, or they may not have smartphones until a certain age, or they may not be on other social media platforms until they reach a certain age. So you can put those terms into your custody agreement if you feel it's important to do so. And you can also put limitations on how third parties are to post about your children on social media. You can say something like, both parties shall take all reasonable efforts to shield children from being posted on Facebook or Instagram, etc., in order to try to keep your children off of the internet. So again, hopefully you can reach an agreement with your spouse, but ultimately, if you have different values around these devices and social media platforms and you can't reach an agreement, if it is important to you to have regulations that you feel comfortable with in place, then you're going to want to seek a court order that there be certain limitations put in place. So you would file a motion with the court essentially asking that your children not be on Instagram or TikTok or other social media platforms until a certain age, or that the parents not post pictures of the children on social media, or maybe you're okay with just pictures but you don't want certain confidential information about their education or medical stuff that's going on. People can post all sorts of things on social media. So you may want to file a motion asking for these restrictions. And ultimately, the court will make a determination about the restrictions that they feel should be in place. The standard the court follows is the best interest of the child. So the court will hear evidence. They will hear what you have to say about what restrictions you feel are appropriate. They will hear what your spouse has to say about the restrictions he or she feels appropriate. And they will ultimately issue court orders that regulate how the children are to be exposed to social media and how they are to be posted about on the internet. So you will get those court orders in place, and then hopefully everybody will follow them. Ultimately, if you or your spouse do not follow the court orders, then either party can file a motion for contempt with the court saying there was so-and-so order in place and my spouse did not follow that order, they violated it, therefore I want them punished for their failure to follow the court order. And those punishments can range from a number of things. It can be, a financial penalty, or it can ultimately be a restriction on parenting time. If there are repeat offenses of violating the court order, then the party may file a motion to modify the parenting plan in addition to their motion for contempt, essentially saying that, there's this court order in place. We've already found that it is in the best interest of the child or children to not be on social media, and my spouse continues to violate that court order. Therefore, they should have a reduction in their parenting time because they are not able to follow what is in the best interest of the child. So those are the basics on how to regulate the use of social media in the context of divorce and custody law cases. As usual, if you have any questions, you can contact our office. And if you are looking for representation in a divorce or family law case in Connecticut, we would invite you to contact our office as well.